Hello and welcome to this session in which we will discuss the Federal Fair Debt Collection Practice Acts known as FDCPA. Now, why do we need to learn about this for the CPA exam? Well, because it says FDCPA. Well, not at all. Maybe just to inform our client in case they are subject to collection, so we need to let them know their rights. That's about it. So the FDCPA is a US law that sets standards for collection of consumer debt. Consumer debt means person borrowed money for personal use, like a credit card to buy a car, to buy something from the mall, to buy something from Amazon. Consumers, specifically targeting the practice of debt collection agency. So who's this act targeting? Debt collection agency. So who are the debt collection agency? So as a customer, you might borrow money from a creditor. And let's assume this is a credit card company. You racked your credit card and now you have $15,000 in debt that you cannot pay. First, the credit card company is going to try to collect this money. If they cannot collect this money from you, what they will do, they will sell your debt to something called collection agency. And what would they do? They would say, this individual owes us $15,000. Guess what? We'll give up our right to collect if you give us, for example, I'm just gonna throw this number out, 50% of it, $7,500. Okay? Now basically the creditor, the credit card company that you originally borrowed the money from, that's it. They no longer deal with you because they sold your credit. They sold you, not your credit. They sold your account to a collection agency. Now they don't tell you this, just so you know. Suddenly you will start to hear from a collection agency saying you owe $15,000. Now, why would they collect more? Because the more they collect than $7,500, this is the profit of this company, the collection agency. And collection agencies are very aggressive. They're going to come after you. I have a cousin who worked at a collection agency, and he used to tell me stories about what they do. They call your neighbor, they call your relatives, they call your friends, they harass you, they want to know where you work because they want to keep reminding you to pay them. It's basically, in a quote, close to harassment. It's their right, obviously, because they purchase your debt. But nevertheless, because they are very aggressive, we have this Federal Fair Debt Collection Practices Act. So it's important to note that the act does not apply to creditors. So whatever we're talking about here does not apply to the credit card company. Because credit card company, they have the right to collect their own debt and they're going to come after you, but rather to agencies that collect debt on behalf of others. So here we're talking about agencies. So they sold your debt or they ask someone to collect the debt on their behalf. That's another option, but usually they sell it. So this is what we need to talk about here, is how does this collection agency work and what rights as a consumer you have, because this is this Collection Practices Act is to do what? To protect the US consumer. Let's go ahead and get started by looking at some of its major provisions. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com. Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today. Limitation on contacting third party. Well, collection agencies are restricted in their ability to contact third parties like your relatives. It could be your neighbor, your brother, your parents. Why do they do this? To harass you, to keep reminding you. This aim is to prevent indirect pressure on the debtor. So you can't do that. You cannot contact third parties. Nevertheless, I'm telling you from my cousin's stories, somehow they go around this. They're very aggressive. I cannot tell you more than that. For example, an agency can call a debtor's friend to find out debtor's address. They can do that, but they cannot reveal that they are a collection agency or mention the debt. Well, think about it. Why would somebody be calling me about their address, right? Hint, hint. But basically what they're trying to do is trying to add pressure on you, but the law says you can't do that. Time restriction on contacting debtors. When can you contact debtors? You can contact them between 8 a.m. and 9 p.m. Simply put, you cannot call them 11 p.m. at night. This will be a violation of this act. Representation by an attorney. Once you tell them, if a debtor is represented by a lawyer, the collection agency must communicate with the attorney. They can no longer contact you directly. This is an example of the violation if the agency continue to call the debtor even after being informed that the debtor has legal representation. You cannot also harass or use abusive language. Collection agency are forbidding from using threatening or abusive language, like bad words, threatening you, so on and so forth. Like threatening physical harm or using derogatory terms would be a clear breach of this rule. Also, they cannot give you false or misleading claims, like if you don't pay, you're gonna go to jail, like misleading the debtor. If you don't pay, non-payment is a violation. Non-payment, you go to jail. Well, this is a violation of the FDCPA. They cannot contact you at work. They are not allowed you to contact you at your place of employment. At least let you work so you can pay them if the employer disapproves, and most employers disapprove. Who wants their employee to be harassed by a third party? When you're working, your employer wants you to focus on your work. So if the debtor's employer communicated that such calls are unwelcome, any further calls to the workplace by the collection agency would also be a violation. Also, under this act, the debtor has significant right to control the communication they receive. Okay, so this section empowers the debtor to terminate contact from the agency under certain conditions. So can you make them stop? Yes. Well, how do you do that? You can instruct them to stop. To do so, the debtor must send a written notice to the agency stating that they refuse to pay the debt and demanding that the agency stop further communication. This is legally binding. So once you put it in writing, they can no longer do that. Limitation of agency response. The only thing that they can do after this letter is to do what? Inform you that they received the letter and they're going to comply with it. And if there's any lawsuit, specific legal action, such as filing a lawsuit or pursuing other legal remedies, they can do that. But that's the only thing. They can no longer call you. Example. Imagine a debtor named Alex who's receiving persistent calls and letters from a collection agency regarding an unpaid credit card. Alex decides that they do not want this and they cannot pay the debt. They write them, said, you know what, I'm not going to pay this, I can't pay the debt, please stop all communication. Once the agency received this letter from Alex, they can only contact Alex to acknowledge the request and to inform them of any legal action, such as filing a lawsuit. So this provision in the FDCPA gives debtor a way to stop harassing communication from collection agency and provide a clear legal framework within which these agencies must operate. Furthermore, the debtor has the right to sue for damages. So this act not only sets standards for debt collection, but also offer remedies for debtor if they were subject to violations of the act by the collection agency. You have the right to sue for actual damages. So if the debtor suffers harm due to a collection agency misconduct, the debtor has the right to file a lawsuit against the agency. The lawsuit can seek compensation for any actual damages suffered. Actual damages might include emotional distress, stress-induced medical problem, lost wages from missed work, or other quantifiable harm resulting from the agency condition. There's also a damage award. In addition to the actual damage, the act allows the person to be awarded $1,000. It's available to debtor regardless of whether they can prove actual damages. As long as they violate, there's a punitive measure by the FDCPA that you have to pay $1,000. Also, the Federal Trade Commission, FTC, plays a crucial role in enforcing this act. It can initiate administrative actions against collection agencies that violate the act. These actions are aimed at compelling the agency to comply with the law and can include penalties, orders to change practices, or other regulatory action. So you'd have the FTC also supporting the act. Example would be Sarah, a debtor who's contacted by a collection agency using harassing language and calling her repeatedly at odd hours. Well, Sarah suffered from anxiety due to these practices and misses work. She decides to take legal action against the collection agency. In court, she presents evidence of her emotional distress and lost wages, seeking compensation for actual damages. Also, Sarah can claim up to $1,000 in statutory damages for the violation. Meanwhile, the FTC, learning of the collection agency's practices, might initiate enforcement action to prevent further communication. Again, all these provision is to make sure that the debtor not only is protected from unfair practices, but also have a recourse, remedies, injustice if their rights are violated. What should you do now? You want to go to Farhat lectures, look at MCQs, additional resources, especially if you're studying for your CPA exam. Invest in yourself. The CPA exam is worth it. And of course, stay safe.